Let's jump right into this explainer because we are looking at a literal earthquake in internet law today. For decades, the web has operated under a pretty settled, comfortable set of rules for tech platforms. But generative AI? It's completely blowing up that foundation. Right now, a series of landmark rulings out of the Regional Court of Munich are fundamentally rewriting the rulebook on who is legally on the hook when an AI algorithm speaks. Okay, let's get into it.
The central mystery we are unpacking today really boils down to one question. Are AI platforms just neutral conduits, or are they legally publishers? You know, for years, search engines have enjoyed this really comfortable legal shield. If you Google something and Google hands you a link to a website with defamatory stuff on it, Google generally isn't held responsible, right? They're just the messenger. But what happens when the AI isn't just linking to someone else's words? What if it's actively generating new text, synthesizing info, and sometimes hallucinating completely false claims? Should these massive tech companies be held liable for what their own algorithms invent out of thin air?
To put it into perspective, historically, internet law treated tech platforms kind of like public bulletin boards. If some random person pins a harmful flyer to a bulletin board, well, you don't sue the company that built the board, you sue the guy who pinned the flyer. The platform is just to host. But generative AI outputs, they are much closer to a newspaper. The company's own system is essentially authoring and publishing the content. So when an AI model spits out something harmful, it isn't coming from a third-party user anymore, it is actively synthesized by the company's very own algorithm.
And this brings us to how German courts are pioneering a massive shift in legal doctrine. Traditionally, under German law, search engines fall under what's called indirect interfere liability. Basically, they don't have to proactively police everything. They're only liable if someone says, hey, this is illegal, and they fail to take it down. Notice and take down. But now, courts are shifting AI into direct interfere liability. Because the AI is evaluating and synthesizing entirely new, self-contained assertions, the courts are just stripping away that old safe harbor protection. They're basically saying, look, AI developers now have a proactive duty, and you are directly responsible for the text your systems create.
So, what was the spark that triggered this whole shift? It started with this fascinating catalyst case at the Munich Regional Court, case 260869/26, for those keeping track. Google's AI overviews generated summaries that falsely accused two Munich-based publishing houses of running fraudulent subscription traps and scams. But here is the absolutely crucial detail. Those defamatory claims, they were completely fabricated by the AI. They didn't exist in any of the third-party websites the search engine actually cited. The AI essentially got confused, mixed up info about other shady companies, and unfairly slapped it onto the plaintiffs. So the court issued an injunction against Google, effectively ruling that they couldn't just blame the algorithm for hallucinating.
To actually pin that liability on Google, the court leaned on a specific German legal doctrine called zu eigen machen, which roughly translates to making content one's own. And it's brilliant in its simplicity. The court reasoned that an AI overview isn't just spitting out a list of links. It's actively affirming a query, it's restructuring the underlying sources into a totally new narrative, and producing assertions that you can't find anywhere in the cited pages. Because the algorithm is evaluating and rewriting information in its own unique structure, the law now treats those words as Google's own direct statements. Legally, the platform has adopted that text as its very own editorial content.
Now, to really understand why this ruling is sending shockwaves through the tech world, we have to look at the sheer scale of the AI hallucination problem. There was this analysis done by the AI startup Umi for the New York Times, and they found that Google's AI overviews answered queries correctly 91% of the time. Sounds pretty amazing, right? But here is the terrifying part if you're a tech company lawyer. Of those correct answers, a massive 50% were completely unsupported by the sources the AI actually cited. So even when it gets the facts right, the AI is constantly making wild leaps of logic and just inventing citations that simply do not exist.
Which brings us to that remaining 9% error rate. If an AI gets it wrong 9% of the time in a vacuum, sure, maybe that's an acceptable margin for a brand new technology. But we are talking about Google here, a search engine handling billions of queries every single day. When you put it at that massive scale, a 9% error rate translates to literally millions of defamatory fabrications and false statements being pumped out every single hour. And under this new Munich precedent, the company is now directly liable for every single one of those fabricated claims, literally as if they wrote them out by hand.
And it isn't just civil courts jumping on this. Regulators are totally adopting the exact same logic. Thorsten Schmig, he's the chairman of Germany's Commission for Licensing and Supervision, explicitly came out and said that AI search engines and chatbots are content providers, and German media law will consistently apply to them from now on.
So regulators have officially ruled that tools like Google's AI Overviews or Perplexity AI are absolutely not neutral search platforms. This completely strips them of their old liability exemptions and forces them to comply with strict media treaties.
What's wild is that this logic isn't just staying in the lane of defamation, it's bleeding entirely into other legal domains too. Take the landmark GEMA versus OpenAI decision. The German Music Collecting Society sued because they realized ChatGPT could basically regurgitate the verbatim lyrics of protected German songs if you just gave it a simple prompt. And just like we saw with the AI Overviews case, the Munich court consistently applied that exact same strict, direct interfere liability to the AI developer. But this time, they dropped the hammer squarely in the domain of copyright infringement.
Now, OpenAI tried to defend themselves, of course. They argue that their large language models don't literally store or copy files like a traditional hard drive. They claim the model just translates statistical patterns into parameters, so any verbatim regurgitation is just they call it a probabilistic anomaly. But the Munich court wasn't having it. They entirely rejected that technical defense. Under what is now being called the parametric fixation doctrine, the court basically said, look, if a simple prompt can pull out exact copies of complex song lyrics, the AI model has clearly memorized the training data, period. The court completely threw out the idea that fancy AI architecture can somehow shield a company from copyright law.
One U.S. lawyer actually had a quote that perfectly synthesizes this core product liability argument facing tech companies globally right now. They said, Frankenstein can't make a monster that runs around murdering people and then claim he had nothing to do with it. I mean, it hits the nail right on the head, doesn't it? If you build an algorithm that independently formulates text, hallucinates facts, or memorizes copyrighted works, you simply cannot hide behind the excuse that it just operates probabilistically. The creator is ultimately liable for the consequences of the creation. So, when we put it all together and compare the before and after of internet law, the paradigm shift is honestly stark. On one side, traditional search engines operate as indirect interferers. They have no proactive monitoring duty. Legally, they are just neutral conduits of third-party links. But on the other side, generative AI overviews are now classified as direct interferers. They have a massive, proactive duty to check for fabrications because legally, thanks to that Zu-eigen doctrine we talked about, they are now considered the outright publishers of their own editorial content.
So what does this mean for the future? Well, the outlook for AI developers is what legal experts call a global dual-track exposure. Track 1 is strict civil tort liability. That means private companies or even everyday individuals can successfully sue them directly for defamation if the AI hallucinates or for copyright infringement if the AI memorizes their work. Track 2 is public enforcement under media treaties. This means government regulators will literally police AI companies as if they were traditional broadcasters or newspapers. The governance architecture these companies are going to need to build just to manage these legal risks is going to be absolutely immense.
So, here's the big question to leave you with. As AI continues to synthesize our information, inevitably hallucinate facts, and just fundamentally reshape how we all interact with the internet, will this Munich precedent be the first domino? Is this what forces global tech giants to finally take full, unflinching legal responsibility for the words their algorithms speak? One thing is for sure, the old days of platform immunity are rapidly coming to an end. Thank you so much for joining me for this explainer. I hope it brought some clear structure to a pretty complex topic. Keep asking questions and keep learning.